Good morning. Are you Ridley McKinney?
Yes, ma'am.
Or McKinley, I'm sorry. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor. And I think we just go on counts 2 and 3 on this.
We do, but we're not going to go forward. We're going to draw allegations.
Okay, state's going to abandon 1. Will he waive the formal reading of that motion?
He will,
I just
Your Honor.
asked you that, I'm sorry. Mr. McKinley, in cause number 19-33345, I have a motion. Good morning. Are you Ridley McKinney?
Yes, ma'am.
Or McKinley, I'm sorry. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor. And I think we just go on counts 2 and 3 on this.
We do, but we're not going to go forward. We're going to draw allegations.
Okay, state's going to abandon 1. Will he waive the formal reading of that motion?
He will,
I
Your
just
Honor.
asked you that, I'm sorry. Mr. McKinley, in cause number 19-33345, I have a motion to revoke your community supervision. Shows that you were placed on probation August 1st of 2022 for the offense of aggravated assault family violence, and that was a 5-year term in prison that was probated for 8 years. Is that correct?
Yes, ma'am.
It alleges in count 2 that you were at a location other than, that you violated your probation because you were at a location other than your residence at approximately 10:24 p.m. April 9th of 2025. And is that true or not true?
It's true.
And then count 3 alleges that you are behind in your court assessed fees. Is that true or not true? And what is the status of that offense from count 1?
I believe it's been refused.
Because it was refused by our office.
Okay.
And the remaining witnesses, it's the same as this one, but therefore we refused. We're not going to go forward with the allegation.
Okay. Is there a no contact order in the probation
No,
though?
they're married.
They're married, Judge, and
With
it's,
children.
I know the optics of it is bad for the kind of offenses that he's on probation for.
Y'all hold it down just a little bit. Go speak.
So it looks bad for the kind of case that he's on probation for, but the complaining witness has come to my office. I've spoken with her. I think
We followed up with the judge. If we had it to move forward.
Okay, I just wanted to check. All right. Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation and order 60-day jail sanction, and it looks like you've got 44 days credit. Is that your understanding?
Yes, ma'am.
State tenders number 1,
no objection.
it's admitted. Any evidence that Mr. McKinley's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order a 60-day jail sanction as a condition for that. These allegations, you will get credit for 44 days. Here's the thing, something's going on, okay? And even at this point, if I think something's going on, the proof that is required for me to revoke your probation is not the same as it's required if we go to a jury. And if there's anything that happens again, whatever's going on between you and her, if y'all are not good together, then don't be together because you're going to end up in prison. The offense that you're on probation for is obviously very serious. You've already agreed, when you got this probation, you already agreed to that 5-year sentence in prison. You violate your probation in any way again, you've got the 5 years. I don't care if it's having to do with her, if it's being out past curfew, if it's not showing up for appointment, this is it. So whatever's going on, y'all need to get whatever help you need. If it needs to be separated, then you need to be separated. Otherwise, you might end up in prison. So you have to figure out what's really best, to be in a volatile relationship in front of your children or be in prison.
Yes, ma'am.
You understand?
I understand.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. As soon as you're released from jail, first thing you do, report back to probation, get going on everything like you're supposed to. All right, good luck to you. In cause numbers 19-333 2340 and 236095 on probation for theft of property and theft of service. And a motion to revoke has been filed in each of those cases. There's a new offense indicted 250297 with the allegation of theft of property. And so that theft new allegation is from offense date of August of 2023. And so obviously that was some time ago. There's a motion, let me get to the right paperwork. In each of these cases, obviously alleging that new offense. Mr. Rojas has filed motion in each of those motion to revoke probation cases that I set a bond, that currently they do not have a bond. Those are deferred, correct? Are they both deferred? Let me double check.
I think they're straight probations.
They're straight probations?
They are.
Okay. So Ms. Leonard isn't necessarily entitled to a bond as if it were a deferred, but we're here to talk about that. Mr. Coleman has filed a state's reply to that motion. I have read and reviewed that and obviously understand Mr. Coleman's position. Mr. Rojas, you may go forward.
Call Ms. Leonard, John.
Ms. Leonard, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay.
Okay, Ms. Leonard, how long have you been in jail now?
14 months.
And it's my understanding that you've got a newborn baby at home? How old is that child?
3 months.
All right, and there's a little, you're having, or before you come in, you're having issues with breastfeeding or with feeding the child?
Yes, ma'am.
Tell the judge about how it's.
My daughter's been breastfed since she was hospitalized at 3 weeks old. She also has a heart murmur. And since I've been in here, they've had trouble with her latching on to a bottle.
So let me ask, it looks like in these motions, the primary allegation obviously is that new offense, and then there is some community service hours, and then very behind in fees and fines. Other than those things, I've got probation here, and if you'll just state your name for the record, ma'am.
Linda Core.
And is there, other than those items, is there any other issues that you are having with Ms. Leonard that I need to be aware of?
No, Your Honor.
Okay. If this new allegation was more recent, I'm not sure what happened with the timeline on this, and doesn't, for this purpose, I guess, doesn't really matter. But because it's been so long, and it looks like other than some fees and community service, everything else has been going well, I'm going to grant the motion to set bond in cause numbers 19-33340 and 20-36095. I'm going to set the bonds in each of those cases at $5,000 in each case. And obviously, if you make those bonds, the first thing you do is report to probation and do everything you're supposed to be doing while you're on probation. Yes, ma'am.
Is that included with the $10,000 bond with the new charge?
You have 3 different bonds. You've got a $10,000 and 2 $5,000s. And so you need to get busy, because while this is pending, obviously would be, I would think, in your benefit to try to get some community service hours done, to get a job, start making some payments, show me and probation and the district attorney that you're trying, because just me setting bonds doesn't mean that you're out of trouble for this. You can still go to the state jail prison. So it's very important that you do everything that you're supposed to while you're on the probation, okay?
Yes, ma'am.
All right, we'll see y'all back at an announcement. All right, ma'am, are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Ms. Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor. No, Your Honor.
I have something, Your Honor.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been the battery's been dead for 3 days.
Okay,
It's not being tracked at this point.
okay, thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right?
What do you want?
I mean, it says right here, she just wants to do her time so she can move on with her life and put the case behind her.
Is that accurate?
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which fee, Ms. Harris? What do you want?
If I can do the 60 days that they offer me and be off
Well,
probation.
60 days is off the table. So that's what the state offered, I think, before.
This is the turning point of the hearing. The defense is asking Judge West to choose rehabilitation over punishment, arguing that mental health, not bad intentions, is at the heart of the problem. But in court, good intentions alone aren't enough. After repeated probation violations and broken promises, the judge has to answer one difficult question. Can this defendant truly be trusted with another chance? What would
That's
you
what the state
decide?
offered, I think, before. Y'all are unagreed. It's up to me to sentence you today.
Yes,
So,
ma'am. Okay, so I'll have to be reinstated.
okay,
It is a misdemeanor, you know,
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take jail time on it. However, the defendant's version does indicate some mental health issues. And obviously, probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow maybe the recommendation, you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are, the mental health state.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously, I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there with,
Okay,
obviously, things that can be dealt with. in therapy.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't do. I'd ask that we revoke her.
so, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI, you tested positive for alcohol, you left the state without permission. I mean, all right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiffs.
Thank you, Your Honor.
Thank you, ma'am.
Can I get my phone and my system?
Talk to the bailiff, just talk to the bailiff. Yeah, come over here and get a thumbprint.